When the framers met in Philadelphia in the summer of 1787, they were intent on creating a national government that would be effective and that would give considerable power to that new national government. But they were also equally concerned about making sure that that new national government wouldn't abuse the liberties of American citizens. So we tend to think of the Bill of Rights and the various amendments to the Constitution as being the mechanisms for preservation of our personal liberties. But the framers didn't include the Bill of Rights in that Constitution when they sent it out for ratification, yet that had been one of their concerns, to preserve American liberties. Instead, the device that they chose to preserve liberty was at that time unprecedented, though we don't give it much thought today. They said the federal government has no power to do anything, nothing, unless that power has been given to it in the Constitution. So by that, they intended to create a situation where powers were limited, and they assumed that liberty would exist in the absence of powers. It was one thing to say that the national government had no authority to act unless it was given a specific power. It's quite another to say what the scope of those specific powers might be. And it was that omission that caused the opponents of the Constitution to resist ratification, or as a fallback to urge that a Bill of Rights be enacted. Congress did so, enacting and states ratifying the first 10 amendments, which we know as the Bill of Rights. The 10th Amendment states a truism, but it is an important truism. The powers not delegated to the United States by this Constitution, nor prohibited by it to the states, are reserved to the states respectively, or to the people. That last clause, or to the people, essentially means that the people of every state have the ability to place limits upon the exercise of the authority that might be used by their state representatives. They can do so in their state constitutions. So effectively, what it states a truism. Where federal power ends, state power begins, but it doesn't tell us much about where federal power ends. The 9th Amendment says, the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. Now, there were two reasons for the 9th Amendment. One was to ensure that the list of individual rights in the Bill of Rights was not exhaustive. So, for example, you put out a list, you might then reasonably think, well, there are no more. That's it. And the 9th Amendment was designed to rebut that conclusion. And it has borne fruit, indirectly, by a whole host of rights that are not enumerated in the Constitution. Among them are some that we think as absolutely rock-bottom basic. The right to be presumed innocent until proven guilty. Nowhere mentioned in the Constitution. More latter versions of these unenumerated rights might be the right to use contraceptives, the right to abort a fetus before fetal viability, and many more. But there was another reason for the 9th Amendment, and that's the one that I want to fasten on for the moment. The implication that the scope of the enumerated powers is so broad that Congress can do effectively anything it wants. And for most of our nation, we've relied upon the Supreme Court to be the entity to declare what the scope of those enumerated powers are. But beginning in the 1930s, the Supreme Court took a new tack. It basically adopted a position of deference to Congress's choice as to the scope of its own powers. It did so essentially by saying that so long as the court could imagine any rational connection, any rational reason why Congress thought its legislation was related to an enumerated power of Congress, the court would bless the legislation. So not surprisingly, over time, Congress has begun to think of itself as possessing a pretty unlimited reservoir of power to address whatever it thinks is important. So granting Congress a virtually unreviewable power to decide upon the scope of its own authority is akin to naming the poacher to be the game warden. It's true that in recent years the court has taken some baby steps to reassert itself as the proper interpreter of the scope of the enumerated powers of the federal government. But like all baby steps, the courts have been unsteady, insecure, and uneven and uncertain. Now, left unused has been the constitutional mandate of the 9th Amendment. The enumeration of certain rights in the Constitution, it says, shall not be construed to deny or disparage the rights retained by the people. Now, what are those retained rights? That's a highly controversial issue, but one of them surely must be the retained right of the people, a right recognized by the 10th Amendment, to self-governance within each state. After all, it is a truism, but it recites a structural principle, that the people of each state are entitled to govern themselves underneath the umbrella of the federal Constitution. We're not talking about violating any of the federal constitutional rights that are contained in what we might think of as the Bill of Rights and the various constitutional amendments. But within that umbrella, a retained right is that right of self-governance. Liberty is also enhanced by permitting people to make the choices that they prefer. Let me give you an example. A national rule is less likely to accomplish that outcome. So if you can imagine a federal union, for the moment, composed of 2 states of equal population, and assume that in one of them, I'll call it Urbania, 90% of the people would prefer a ban on hunting. But in the other state of equal population, which I'll call Rustica, only 20% would favor a hunting ban. So if you enact that at the national level, 55% of the people will be pleased. But if you leave that decision to the states, Urbania will ban hunting, Rustica will permit it. Now 85% of the people will be pleased, and what's more, hunters in Urbania are free to move to Rustica. And those who abhor hunting who live in Rustica are free to move to Urbania. That choice, both of freedom of movement and of how to arrange one's local affairs, is denied to the extent that a nationally uniform standard is imposed. I think that the right to choose policies that suit the local citizenry is at the heart of the rights retained by the people. And that's why the command of the 9th Amendment, that courts construe the grant of powers to the federal government in a way that preserves that right, is critical to the preservation of liberty.